right, good morning and welcome to the Court of Criminal Appeals January docket here in Nashville. Let me introduce our panel. To my right is Judge Bobby Holloway from Murray County, Tennessee. To my left is Judge Tim Easter from Williamson County, Tennessee, and I am Judge Jill Ayers from Montgomery County, Tennessee. And I appreciate Judge Holloway allowing me to preside today. He did so because we have some special visitors. We have the District Attorney's Office for the 19th Judicial District Youth Council here. So we have high school students from the Clarksville, Montgomery County area, and we welcome you all here today. We're glad you're here. Just a little bit for the students' benefit. I don't think y'all have had the experience of going to trial court yet, but this is the appellate level. So it's a little different from what most people think about as far as courtroom situations. There's not any kind of testimony or witnesses or anything. You're going to hear lawyers from both sides argue about the issues that happened at the trial court level that they're asking for us to review. And so we've got some great attorneys here today that you will hear from, and each attorney has 20 minutes per side, and if the appellant wants to reserve any rebuttal time, please let us know so we can let the timekeeper keep up with that. Anything else I missed?
Nope.
All right, any preliminary matters, Madam Clerk?
None that I'm aware of, Your Honor.
Okay, very good. Then if you'll call our first case.
State of Tennessee versus Richard Daran Angel.
Good morning, Your Honors. Ben Ball on behalf of the state. I'd like to reserve approximately 3 minutes.
You're not used to saying that, are you?
I may just be saying that. I may not use it, but I would like to reserve it nonetheless. Judge Holloway, this case may seem a little familiar to you. It's very similar to the Tate and Ogle case that you sat on over a year ago. Unlike Tate and Ogle, this is free from the procedural hurdles that Tate and Ogle failed to clear. Here, the defendant was charged with contractor fraud in the Van Buren County Circuit Court. Before trial, he moved to dismiss the indictment, raising a vagueness challenge both facially and as applied to the use of the word substantial in the contractor fraud statute. The Circuit Court found the statute vague on its face, and the state has appealed. The trial court here erred for two reasons. First, the court erred by addressing the facial vagueness challenge. Unless a vagueness challenge involves the First Amendment, like a case we'll be talking about later this morning, the person challenging it must first show that the statute is vague as applied. So a pretrial challenge here is premature. It requires the development of a factual record, which motion to dismiss an indictment is not intended to develop. And even if it were, it was not developed.
Well, that was going to be my question. There were no witnesses, nothing put on other than arguments at the hearing. Is that correct?
That's correct, Your Honor. We have no evidence.
A couple of questions. I had one gets to that. If the defendant had put on proof, testified himself or whatever, you could still challenge an indictment pre-trial and get here, correct?
Well, Your Honor, it would, if there had been proof, this would be a better situation. I would posit to this court that a pre-trial motion to dismiss is not the proper motion to have this hearing. We look at the kind of arguments or issues that are presented in pretrial motions, and typically they don't involve a lot of development of the record. Because we don't ask the trial court to typically sit in place of the jury and make factual decisions before trial. So I would posit that the best time for a challenge like this would be post-trial at the motion for new trial phase.
Well, I don't want you to waste your time speculating about what if, because it is what it is. There was no evidence here presented, correct?
That is correct, Your Honor.
My second question is, the way I read the defendant's appellee's brief, they seem to agree with you.
I think they do, Your Honor, and I think we're probably all in agreement at this point that it has to go back. except the defendant is still making sort of an argument that this is, that there's enough evidence here that this court could find it.
There's no evidence here.
There is no evidence here. There are statements made in motions. There are statements by counsel made at the hearing, but as this court knows, that's simply not evidence. So I would suggest to this court that there's no reason really to address the second issue here when the first issue is precludes this. It requires this court to remand. But I'm happy to address the facial challenge if this court would like. I would just briefly note that substantial is a common word capable of being easily understood. It's considerable in amount, value, or the like, large. And in the context of the contractor fraud statute, a person of common intelligence can reasonably understand what it means. A contractor is criminally liable for failing to refund amounts paid under contract when they performed no work that is considerable in amount or value. And portion in this statute is important because it's part of the context, and context in these statutes is always key. Portion indicates that the construction project may not be complete, and it only arises after 90 days. So this is a flexible standard, and that does not make it vague. Our law is full of flexible standards. And in the construction industry, it is commonly understood that substantial work varies from project to project and depends on the stage of the given project. And the intent to defraud here also clarifies the limited scope of this statute. If we look at entertainment resources, which is the case that the defendant relies upon heavily. First of all, that's a First Amendment case that doesn't really apply here, but there where it uses substantial, we're talking about the percentage of a business's stock that is adult in nature. It's much more easily, like the legislature could have given pretty clear guidance on that, whereas here, what we have it's dependent on context, on the phase of construction, on how far in that phase along you are. So in this case, substantial portion is not vague, and this statute is not vague on its face. Again, I don't think this court really should reach that.
Well, we don't have any facts even
We
to
don't have-
determine whether a substantial amount of work was done. Is that correct?
That is right, Your Honor. So until the defendant can show that it is vague as applied to him, he cannot show that it is facially vague. So yes, Your Honor, that's correct. This court should simply remand this, reverse and remand.
Thank you.
Thank you, Your Honors.
I'll start out by telling the visitors we have 2 Murray County lawyers at the first case, so enjoy it. At least one former Murray County lawyer and one current.
He's still Murray County.
Just like I'm still Montgomery County.
That's right.
That's right.
Good morning, Your Honors. Kendall Stopper-Jones from the Appellate Division on behalf of the appellee. My friend from the other side is correct. We agree with him. This is not a facial challenge. This is not a facial constitutional issue. It's not a First Amendment issue. This is an as-applied challenge. So, and I know the court knows this. We've talked in our office about whether or not the best thing for this is to address it here, which we argue there is enough in the record for this court to go forward on this.
So how is
But
there enough in the
whether-
record?
So this case is interesting. The contractor fraud, and the reason this is so important, these cases are popping up all over the state. And I know you all know that not just from what we see from the public defender's office that are coming across the state, but I don't know why it's become, I don't know if there's more contractor fraud during COVID or stuff, but we're seeing it across the state. This is an issue that if you send it, it's going to come back.
I think
And
there's, with the case that the general mentioned, really is more a procedural issue.
is.
And
It
really
is.
doesn't get to
It is, I believe in Tate versus Ogle, Tate versus,
Ogle.
Tate and Ogle,
Tate and
Judge Ogle.
That's right.
Did not dismiss all of the indictments. The contractor fraud statute is so similar to a theft. I'm not really sure. I mean, but here it is, so we have to deal with it.
Well, I know there's one case that we reversed on out of Dixon County.
There was a recent one,
And the state didn't appeal, which I thought was interesting. The state didn't file Rule 11 in that case, and I'm blanking on the name right now, but the state didn't file.
There's one that has addressed it, but it was more of there wasn't a criminal intent.
That's it.
Yeah, it ended up
And
really
I
being
cannot remember the
contractual,
name.
civil.
That was it.
I think that was
So
your
it's-
case.
I think it was actually
I
mine.
can't remember the name of it.
I think it was mine.
Just typical.
Oh, was it yours?
I think.
It was this panel, and sadly, none of us can
Ah.
remember the name of it.
I can't either. It's in my brief, and I don't want to look because then I'll break my. But anyway, so part of the reason why my brief was so lengthy, despite agreeing with the state, is because there are a lot of things, if this court does send it back, that the court below needs to consider before it comes back up. So this can be something that is dealt with.
In that regard, let me ask you one question, and it's sort of something that General Ball said we may not need to get to. But how does the substantial portion the jury's asked to decide differ from other things we ask a jury to decide, say criminal attempt, which is substantial steps, or criminal negligence, which is substantial and unjustifiable risk, those types of things?
Those are defined, we've mentioned in the brief, those are defined substantial steps, substantial, it's similar, but like the difference between bodily injury and serious bodily injury. Those are not just things that our courts have developed through a body of case law. There are jury instructions to help them figure out these things. A substantial step, their entire course of conduct has to be corroborative. Criminal responsibility, it's not just that somebody's present, but that they have to do other things that are indicative of being involved in the commission of that crime. We don't have that here. Substantial portion is just for everybody in the audience. The statute that we're talking about is a contractor fraud statute, and it criminalizes a contractor or a home improvement provider, because a contractor is someone who does a project, is licensed by the state, and does a project over $25,000, and that can be a mason, that could be a general contractor, that could be a plumber, subcontractors. So substantial portion is covering very disparate businesses and tradespeople in its substantial portion discussion of it. And I think I've lost my track. But to get back to what my friend from the other side was saying about being ripe for disposition, I agree that the trial court applied the wrong standard here, but in this case, once the record shows that some work was done, and it is not, as the state and the legislative history indicates, some fly-by-night scammer who takes somebody's money and runs, that's where it really becomes difficulty. At what point does this go from a civil contract where somebody's just disputing what work was done and the value of that work to someone who's actually being a criminal? And the standard there's enough in the record to do that. It was uncontroverted that the people who sought and contracted with Mr. Angel told him when they canceled the contract after they found out that their property wouldn't support a septic tank, we want our money back except $1,000 for the work that's been done, right? So they've acknowledged that there's work, and they valued that work at $1,000.
What in the record supports that?
I believe it's on the record that
I mean, there's no
technical record. There's the record that the state put together includes the criminal complaint that they filed prematurely, which shows everything that I've just stated.
But that's not
uncontroverted by the state at the hearing.
That's not evidence, though, is it?
Evidence of what?
Evidence. I mean, we tell juries, just documents and statements of lawyers and discovery and that sort of thing. Is in evidence, wouldn't that require some testimony?
Well, and then our argument becomes what evidence is there that's going to support this? The state has agreed that some money has been taken, or some work has been done. The state at the hearing stated that Mr. Angel wanted to charge $14,000 for going out there and putting down some stakes.
So that was statements made by the
That was statements
DA?
made by the DA. That's correct.
Is that evidence?
Well, if the state's going to argue something at the trial court level and then say that it's not evidence here at this level or some agreement that they failed to object to, I would argue that they've waived any argument that they had to making a representation in the court below and then saying, well, we don't think that here. Once you get to that point that there's some work that's been done, as the state has acknowledged in its statements and representations to the court, as an officer of the court, it becomes a question of law. I don't think the presentation of any more evidence would be helpful in this case because, and I respectfully disagree with the state's argument that it needs to go back and have a jury trial. I had 21 jury trials in 4.5 years, and just telling somebody to have a jury trial is a big undertaking for someone to do on what is essentially a question of law, which is what this is.
Well, it seems like it's a question of fact, maybe not a very clear one, what is substantial and what is not substantial. And it seems like it would be based on the total price of the project, how much work was actually done, how long he took to do it.
And then my question, Judge Holloway, becomes, and what metric do you apply for determining what portion of that? Is it in the Knoxville case? It's a First Amendment case, but the store was trying to bring its stock of smut in compliance with whatever the allowable amount for the city of Knoxville was, and they wouldn't be told. They reduced it from 85% to 85% to 50% to 30%, and it was still found to be like at what point there's no metric here. At what point does the amount of work that's done become criminal? And I think the problem here is also illustrated in that you have people who entered into a written contract. That's not what's required for the statute. It can be oral or written. Who entered into a written contract with somebody on June the 4th, paid him a portion of that, $14,000 of, I think, a contract of 28, or maybe $16,000 of a contract of 28. Told him, Mr. Angel, that the neighbor's property perked, it was able to support a septic tank. We're fine, just go ahead and do whatever. He gets into whatever kind of preparatory work is going to be done. They find out 3 days later, June 4th, 9 minus 4 is 5. 5 days later, that the property won't perk, and then they text him, the contract's closed, we don't need you, give us everything back but $1,000. And at that point, I mean, the state has acknowledged he's put out flags and he's done this. They've acknowledged that he's done some work, and even the alleged victims in this case have acknowledged he's done some work by offering to tell him to keep that amount of money.
But we don't even have the contract that says what work was actually to be performed, do we?
That would have been nice to be in the record. No shade. But we have Mr. Magdick, or Mr. Angel, on the 13th, so 9 days after the contract, returns $1,500, and then by July 6th, these people are at the sheriff's department just filing a criminal report. So there's this incentivizes people who have the ability to write a $14,000 check to immediately go and pursue this as a criminal matter rather than a civil contract matter. They waited and they got the indictment later, and the indictment alleges an offense date of sometime in 2023, far after the contract was established. But I mean, we're not saying that some more facts would not help the record, but I think this is still at its core a matter of law, which doesn't require the jury. And in fact, I think asking a jury to stumble through this with no jury instruction as to what constitutes substantial. I mentioned a federal case where there was a police officer who told at a hearing that he thought if someone didn't fulfill 100% of a contract, that they were guilty or they should be criminally charged. And in that light, the standard for unconstitutional, vague or overbroad is that the language of the statute fails to give fair notice of what conduct is unlawful, and then it fails to provide a reasonable definition or a reasonable description to police officers, law enforcement, judges, juries, anybody who's going to be responsible for interpreting the law as to what kind of conduct is prohibited, and that invites, as we've seen here, kind of arbitrary distinctions on at what point. And it's not just, it's contractors and home improvement contracts. It's not just like, I don't know, if we were lawyers in a private practice, we bill our time, and we have to show that. Well, good lawyers have to show that. Like contractors or people who are small business owners may have that, but in this case, it's just at what point does it become criminal and not just a matter of civil dispute? You're asking somebody who doesn't understand, well, in order for a property to perk, you've got to clear some space, you've got to prep the site, you've got to determine angles and stuff, and they may not appreciate that, but they've not gotten the opportunity here to discuss that in a civil court. I mean, it's under $25,000, so it could be a general sessions matter. And then you get into the fact that this substantial portion covers not just like very disparate things. I mean, it's anything that touches a home. The statute that's referenced at 62 for home contractors, home improvement 626501 that is referenced by the statute here. Driveways, swimming pools, porches, garages, landscaping, fences, Demogorgon traps, roofing, painting, fallout shelters. Like, it's everything. So it's what percent of a fallout shelter becomes a contract taking versus is it, I can hide from a tornado but not a nuclear blast. And I'm not saying that the court needs to provide an end-all description, but if the court sends this back, it needs to be something very explicit for the trial court to understand that this needs to be as applied to the facts of the situation here, and give some kind of metric or definition that will allow this court to determine what needs to be done in order to solve this, so that we stop seeing these pop up across the state, whether that's a jury instruction, whether that's that the statute needs to have something amended to it. But it'll be very helpful, not just for people who run small businesses that are going to worry about somebody not being pleased with their work and going to the sheriff, so that instead of hiring a lawyer for a civil contract dispute, they're posting bail or bond money for a Class C felony that takes away their right to vote and own a gun.
Couple of comments. One,
Yes.
the case that we were talking about earlier was Purdue.
Purdue.
Thank you.
I knew it was
And
everybody.
there was no Rule 11 filed in that by the state, but just interesting. But also, I find it intriguing and almost fascinating, based on your brief, the language in the legislative history. We're dealing with the exact
Same.
thorns that you're arguing here today that was anticipated by our friends next door.
And I think what happened in the representatives, I think they thought that this would be something good for the people who are probably taking advantage of elderly people who are getting, like wheelchair ramps put on their house or something like that and just taking off. But it's now starting to cause some real problems and almost being weaponized to the point. And I'm not saying that that's necessarily what happened in this case, but at this point, this case gives us enough if this court feels that it wants to address it, that's great, and I've addressed those arguments if this court wants to consider those. And if this court needs to send it back and feel like the record needs to be more developed, that's great too. So,
Right.
I think that's all.
Thank you.
Thank you, Your Honor.
Thank you.
General Ball.
Your Honors, I believe that I was the attorney on Pardue, the home improvement fraud case out of Dixon. And I think that case should help alleviate some of your concerns about this, and that the scienter element here is very important. It illustrates, because that is what that case ultimately resolved on. There was found that there was insufficient evidence of intent to defraud. So, because you don't just need, it's not just a substantial portion, there has to be an intent to defraud. So there's a protection built into the statute for contractors who are just bad at business or who encounter some catastrophic event. There has to be an intent to defraud there. But again, this court need not get to the facial challenge. My friend on the other side and I agree on many aspects of this case. We agree that before there could be a facial challenge, there must have been an as-applied challenge. But our position is that you cannot get to, because there was not the as-applied challenge, because there was not evidence, you cannot get to the facial challenge. And Your Honor, let me reiterate, there is no evidence here. Yes, we have the statements of counsel. That's not evidence. There's nothing here. I mean, you all were trial judges. You know that if there's a presentation of evidence, you have a finder of fact. That finder of fact makes findings of fact. There's nothing like that here. We don't have any evidence. And even in the statements of counsel, counsels appears to disagree about what the facts are here. The opposing counsels give different sort of very brief descriptions of this, but there's certainly not the kind of facts that this court would need to look into this. So again, I would urge this court to reverse the trial court and remand for further proceedings.
I guess, and again, I agree with what you're saying and what Mr. Jones is saying about the as-applied versus facial vagueness, but I just guess I have a hard problem understanding how you can get from a unilateral termination by one side to this contractor substantial completion issue in a criminal case. You got the homeowner unilaterally terminating the contract. To me, that's a contract issue. And how you transform that into a criminal case, I can't figure out. So, but that really doesn't have anything to do with your case today. Just that's what I'm sitting here thinking.
Yeah, I would say I certainly understand your policy concerns there from the legislative standpoint, but it's from a vagueness standpoint. I would again urge this court to reverse the trial court and remand for further proceedings. Thank you, Your Honors.
Okay. We appreciate your arguments and your briefs, and we will issue an opinion on that. If you'll call our next case, please.
State of Tennessee versus